your hand, I know I. Yeah. It's gonna go over a lot of information, so just make sure you pay attention, because they're going to determine if you can get a quarter point or whatever. There's gonna be a lot of information. All right. Kind of put, like, you put in our session, the Terrence presiding.
You may be seated. Good morning, ladies and gentlemen. I'd like to welcome you to the county court at Level 2. My name is Mr. Terrence Holmes. I'm the presiding judge here in county court at Level 2. You have been asked to come to court this morning for what we call an arraignment. And what the arraignment is an opportunity for the court to tell you what you've been charged with, what your rights are, and what your options are concerning your case. Now, the case that you have in this court is a criminal case. It is a misdemeanor criminal case. Criminal cases are divided into felonies and misdemeanors. Your felony cases are referred to as your most serious type offenses, whereas your misdemeanor cases are normally referred to as your petty offenses. Does not mean that they're not serious, it just means that they are not as serious as a felony offense. And when I use the term serious, what I'm talking about the facts of the case and the possible punishment that a person can receive if they are convicted of the offense. Now, felony cases are divided into 5 categories. We'll start at the top, work our way on down to the bottom. You have capital murder, first-degree felony, second-degree felony, third-degree felony, and the state jail felony. If a person is convicted of a state jail felony, the range of punishment is minimum 6 months to a maximum of 2 years in the state jail, and a fine that does not exceed $10,000. If a person is convicted of a third-degree felony, the range of punishment is minimum 2 years to a maximum of 10 years in the state penitentiary, and a fine that does not exceed $10,000. If a person is convicted of a second-degree felony, the range of punishment is minimum 2 years to a maximum of 20 years, and a fine that does not exceed $10,000. If a person is convicted of a first-degree felony, the range of punishment is minimum 5 years in the state penitentiary and a maximum of 99 years to life, and a fine that does not exceed $10,000. Now, if a person is convicted of the highest felony, which is a capital murder, the range of punishment is minimum life in the state penitentiary without the possibility of parole or death by lethal injection. Now, as I mentioned to you earlier, you have a misdemeanor case, so you don't have to worry about those type of punishment. Now, misdemeanor cases are divided into 3 categories. We'll start at the top, work our way on down to the bottom. You have the Class A misdemeanor, the Class B misdemeanor, and the Class C misdemeanor. The Class C misdemeanors are cases that start in the city court, which is the municipal court, or they start in the JP court, which is the justice court. Now, if a person is convicted in one of those courts, then they can appeal their case, and then the case comes here. Now, the range of punishment for a Class C misdemeanor is fine only. The fine cannot exceed $500. You cannot be given jail time. It's fine only. However, if you fail to pay the fine, or if your fine was converted to community service and you fail to perform the community service, then the court or the judge can issue what is called a capias pro fine. That means a warrant for your arrest to either pay the fine, or you can sit the fine out in jail and you receive $100 credit for every day that you sit out in jail. Now, a Class C misdemeanor could be like not having your seatbelt on, speeding, having invalid inspection sticker. Those are Class C misdemeanors. Now, the next highest misdemeanor is a Class B misdemeanor. With the Class B misdemeanors, the range of punishment is minimum 0 days to a maximum of 180 days, which is 6 months, in the county jail, or a fine that does not exceed $2,000, or you could be given both such fine and confinement. And the highest misdemeanor is a Class A misdemeanor. Class A misdemeanor punishment, minimum 0 days to a maximum of 365 days in the county jail, which is 1 year, or a fine that does not exceed $4,000, or you could be given both such fine and confinement. Now, as a defendant in a criminal case, you have rights. You're gonna talk about the rights, some of the rights that you have as a defendant in a criminal case. The clipboard, everyone who's here for arraignment should have a clipboard. Who does not have a clipboard? Okay, 1, 2, 3. We need 3 clipboards. Our bailiff is going to get some clipboards. Clipboards out there. Now, the bailiff is going to get some clipboards for those individuals who do not have clipboards. Sir, what's your name?
Anthony Cormier.
Cormier?
Yes, sir.
But not these little piece of papers that they're passing out. I mentioned that I caught everybody walking in.
Okay.
Any more than on the county.
No, there's somebody else just
They don't
came
have any
in.
more clipboards out there?
You thought any more clipboards?
Yeah, if you put the exact amount that's on the docket.
No, I don't think there's any clipboards sitting around. No. Nope. Oh, those 2 people. Okay, now, what I'm going to do, I'm going to go over the paperwork that's on the clipboard. And we're gonna talk about the right that you have. First right, I will talk about is the right to have an attorney. The information on that clipboard is about your right to have an attorney. Now, the first document that you should have pulled up on the clipboard is titled Judge's Explanation of Rights to Defendants Without Attorney. That should be the first document. All right, now, on that document, it states that as a defendant in a criminal case, you have 3 options. Number 1, you may hire an attorney. Number 2, if you cannot afford to hire an attorney, you may request that an attorney be appointed to represent you. And number three, you may represent yourself if you waive or give up your right to have an attorney. Now, the first paragraph states that if you want an attorney and you have enough money to hire an attorney, your case will be reset. Reset means that you will be given another court date to give you time to hire your attorney. The next paragraph states that if you want an attorney but you cannot afford to hire an attorney, you may request that an attorney be appointed to represent you, but you must first fill out or sign a financial questionnaire. Now, the financial questionnaire is another document that's on the clipboard that is titled Jefferson County Affidavit of Entity. It's a 3-page document. Okay, that's for individuals who will be requesting a court-appointed attorney. You would have to fill out the first page of this document, and then on the second page, you will fill out the top of the document that states defendant's oath, and then you go to the middle of the document that says unsworn declaration of defendant. Once you fill that out, you'll stop. Now, for those individuals who will be waiving their right to an attorney or giving up their right to have an attorney because they want to represent themselves, you'll have an opportunity to talk to one of the two prosecutors that are in court, the assistant district attorney. And the reason why you will have an opportunity to talk to them about your case is because you will be representing yourself. In essence, you'll be acting as your own attorney. Now, you cannot talk to them about your case unless you first sign a written waiver. The written waiver is another document that is on the clipboard. That is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. Now, be aware that there are dangers and disadvantages of self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. Now, if you choose to represent yourself, you may change your mind at any time and request that an attorney be appointed to represent you. Now, at the bottom of this document, the first document, if you want to hire your attorney, if you want to hire an attorney to represent you, the only thing you need to do is sign this document. You're going to place your initials on the first line to the left that says, I want to reset this case to hire my own attorney. You're going to place your initials here, and then you'll sign it at the bottom and date it, and then that's stop. You won't have to sign no more documents. Okay? That's the only people who will hire an attorney. If you want to apply for a court-appointed attorney, then you will place your initials on the third line to the left, right? Where it says, I want to apply for court-appointed counsel. And you will sign your initials on the line that's titled defendant. You will date it today's date, February 4th, 2025. And then you would have to sign, you would have to fill out the first page of this Jefferson County Affidavit of Indigence, the second page where it says defendant's oath and unsworn declaration, and then you will stop. All right. Now, if you are representing yourself, you want to represent yourself, the only thing that you would have to do is sign the fifth line, put your initials on the fifth line of this first document, judge's explanation. Sign your name on the line that's titled defendant and dated today's date, February 4th, 2025. And then you would have to read and sign the document that is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. You have to read this, sign it, and date it February 4th. So I'm gonna give you a brief summary. If you want to hire your own attorney, you sign one document. Okay? If you want to hire an attorney, you want to sign one document, you don't have to worry about nothing else. Put your initials on the first line to the left at the bottom, your signature on the line where it says defendant and date it today's date. If you want to apply for a court-appointed attorney, then you would have to sign this document place your initials on the third line of this document, sign your name where it says defendant and today's date, and then you would have to fill out the first page of the document that is titled Jefferson County Affidavit of Indigence, and then the second page where it says defendant's oath and unsworn declaration. If you want to represent yourself, place your initials on the fifth line of this first document, sign it and date it, and then you will fill out the form, read the form that says waiver of counsel for purposes of entering a guilty plea or proceeding to trial, and you will date today's date. Do we have any questions? Okay. Now, we're gonna give you time to fill out those documents, but in the meantime, I'm going to go over some other rights that you have. Another right that you have is a right to have a trial by jury. When a young lady is sitting in that area, we call that the jury box. 6 citizens from Jefferson County will be selected to serve as jurors in your case. They will listen to all of the evidence that is presented. They will listen to the arguments of the lawyers, or if you're representing yourself, the argument and the argument of the district attorney, assistant district attorney, and then they will deliberate in the jury room, and then they will decide whether to find you not guilty or guilty. You also have a right to waive or give up your right to have a trial by jury. By waiving or giving up your right to have a trial by jury, you will not be having a trial by jury. Your case will come before the court or before the judge in one of three ways. It can come before the judge by way of a trial. We call that a bench trial. And somebody might ask, why can't you have a trial if I waive my right to have a trial by jury? Well, you're gonna have a trial by judge. The judge will be the judge and the jury. We call that a bench trial. Now, the other way that the judge will listen to all of the evidence that's presented. He will listen to the arguments that's presented by the attorneys, or if you're representing yourself, you and the assistant district attorney. The judge will apply the facts to the law and decide whether to find you not guilty or guilty. You also have a right to enter into a plea bargain agreement. In essence, if you decide to plead guilty, which you're telling the court that you committed an offense that you can charge with, or if you enter a plea of no contest, you're telling the court that you're not fighting the charges, you'll have a right to enter into what is called a plea bargain. A plea bargain is an agreement that you work out with the state, with the assistant district attorney to settle your case. We call that a plea bargain. Now, if you have a plea bargain, we call that an agreed plea bargain. It comes before the judge, before the court. And the judge can do one of two things. The judge can accept or reject your plea bargain agreement. Now, if the judge accepts your plea bargain agreement, if you decide within 30 days that, you know what, I think I've been wrongfully convicted, or the court committed an error by convicting me, I want to appeal my case. And so you have to get permission from the judge that follows the plea bargain agreement. If the judge gives you permission, your case is going to leave this court and it's going to go to the Ninth Court of Appeals, which is right above us on the third floor. Those 4 judges will review your case. They can do one of two things. They can grant or deny your appeal. If they grant your appeal, they can just simply find you not guilty. Or they can send the case back down to this court and order this court to give you a whole new trial. If they deny your appeal, then you can appeal it to a higher court than the Ninth Court of Appeals. You can appeal it to the Texas Court of Criminal Appeals, which is located in Austin, Texas, it is the highest criminal court in the state of Texas. You have to file what is called a pro se petition for discretionary review. What that means is this. Pro se means that you're representing yourself and you're petitioning or asking the court to review your case. Why? To see whether or not your appeal should be granted, or to see whether or not you were wrongfully convicted in this court, or this court committed an error by convicting you. They can do one of two things. They can either grant or deny your pro se petition. If they grant your pro se petition, they can simply find you not guilty. Or they can send the case back to the Ninth Court of Appeals with orders, or they can send it back to this court, or in this court to give you a hope to trial. Or they can deny your pro se petition. If they deny it, then at that point your conviction will stand. Okay. Now, you also have a right to have, if you're in a state and have been unable to reach an agreement, a plea bargain agreement concerning your case, but you still want to go forward and you plead guilty or no contest, then your case will come before the court, the judge, on what we call an unagreed plea bargain. In essence, you're in the state, have not been able to reach a plea bargain agreement, and so the judge will decide what your punishment will be in the case. And the judge can give you punishment anywhere within the punishment range for your offense. Okay. Now, you also have a right to have witnesses to come to court, to call witnesses. You have a right to call witnesses. What witnesses do, they sit in a chair where that microphone is, that we call that the witness stand, and they can either testify for you or against you. If you're representing yourself, you can ask some questions. If you have an attorney representing you, your attorney can ask some questions. We call that either direct examination or cross-examination. Now, you also have a Fifth Amendment right. Well, first one, you also have a right to waive your right to call witnesses, meaning that you have a right not to call witnesses. If you do not call witnesses or you waive your right to call witnesses, that does not mean that the state will not be calling witnesses, because the state will be calling witnesses in your case. Now, you also have what is called a Fifth Amendment right against self-incrimination. I know some of us look at television, at these shows like Law and Order, and you might see somebody when the police goes up and talk to them, or when they're in court on the witness stand, they ask them the question and say, well, I'll take the fifth. And what that basically means is I'm not saying anything. In essence, I'm invoking my Fifth Amendment right, or exercising my Fifth Amendment right against self-incrimination. You have a Fifth Amendment right against self-incrimination in the United States Constitution. But you can waive or give up your right, your Fifth Amendment right against self-incrimination. And by doing so, if you waive or give up your right, you will be testifying in your case. You also have a right to have what we call discovery. Discovery means that you have a right to see that evidence that the state is going to be using against you, or that the state has against you in your case. In essence, you have a right to see or discover what that evidence is that the state has. For example, you have a right to see your statement, witness statements, police reports, lab reports, photos. You have the right to see video recording, listen to audio recording, see documents or instruments. You have a right to have access to those things to see what the state is going to be using against you in your case. Now, you can waive, which means give up. You can waive or give up your right for discovery if you choose to. Now, everyone that's here today for arraignment, charges was filed against you, you've been arrested, placed in jail, and you're out of jail on bond. You're out of jail on what we call a cash bond, which means you paid the full amount of the bond to get out of jail. You're out of jail on a surety bond, which means that you paid a bondsman a percentage of the bond to get out of jail. Or you're out of jail on what we call a PR bond, or a personal recognizance bond, which means that you did not pay money to get out of jail. You was released under your own personal recognizance. I said that to say this. Every day that you spent in jail, can be used as credit towards your punishment. So for example, let's say you spent 5 days in jail, and the state is offering that you serve 5 days in jail. That means you will not have to serve any more time in jail because you'll be given credit for the time that you have already served. Now, if you spent 5 days in jail and offer 7 days in jail, that means you would only have to spend 2 days in jail because we'll subtract the 5 from the 7 and it leaves 2. Now, if the state is offering you fine and court costs, every day that you spend in jail, you receive $100 credit toward your fine and court costs. So for example, in the scenario that I mentioned to you earlier, if you spend 5 days in jail, that's $500 credit that can go toward your fine and court costs. So if the state is offering you fine and court costs of $500, that means you won't have to pay anything because the 5 days that you spent in jail has already paid it off. Therefore, the fine and court costs would be taxed and retired, which means you already paid, you don't have to pay anything else. Now, if they offer fine and court costs of $700, you spend 5 days in jail, that means you would have to pay $200. Why? Because we will subtract the $500 that you have credit for from the $700 and leave $200. Now, you would have to pay that on the day that you dispose of your case. Now, if you cannot pay the $200 on the day that you dispose of your case, no problem, because the court can put you on what is called a payment plan. That means you pay so much money until it's paid off. Now, sometimes individuals may not have the money to pay it off even on the payment plan. No problem, because we can convert what you owe to community service. So, in essence, for every 1 hour community service that you perform in a nonprofit organization in our community, $12.50 will go towards your fine and court costs. So for example, if you work 8 hours community service one day, that's $100. That's going towards your fine and court costs. So in the scenario, you work 2 8-hour days, that's $200 and it's paid off. Okay? Now, Jefferson County has a program for first-time offenders. If you haven't been in trouble before, first time being in trouble, they have a program that is called pretrial diversion. And with the pretrial diversion, when I say Jefferson County, I'm talking about the district attorney's office, they will dismiss your case. And you can get it wiped off your record. Okay? We call it an expunction. All right, for first-time offenders, in order to qualify, it has to be a case that does not involve, unless unlawful carrying a weapon or resisting arrest, has to be your first time getting into trouble. And you have to have an attorney to assist you in just filling out the application to get into the program. Okay? If you meet that criteria, first time in trouble, it's not an unlawful carrying a weapon or resisting arrest, you get an attorney to help you fill out the application, you get in. Once you get in the program, they will dismiss the case, but once you complete the program, you can get it expunged. Expunged means erased, wiped off, or deleted from your criminal record. All right. Now, if you're a veteran of any one of the branches of the United States military, the district attorney's office has another program that is called Veterans Court. It's for veterans only. You could be a veteran of any one of the branches of the United States military. And what they will do, once you get into the program and complete the program, they will dismiss your case. And then you can get what is called a non-disclosure. And what a non-disclosure is, your record is sealed. Okay? It's sealed to the general public. Now notice I said general public. The general public, which is most of the public, cannot have access to it, but the government can. All right? But the general public cannot have access to it because your record is sealed. So if you go to mobile oil or something like that, try to get a job, it's sealed. They can't see it. Right? The general public, their name is not on the list that have who have access. Basically, it's the government that have access to it. Now, this court, County Court Outlaw number 2, has a program that is called the CSI program. This is a program that God led me to start in March of 2017. The program is designed to address the issue of what we call recidivism. Recidivism is just a word that means people commit crimes over and over, okay? And so how do we address it? We address it through the Community Safety Initiative. And with the Community Safety Initiative, the program that we started within the first 100 days of taking off, that program is designed, well, first of all, the way it's designed, we have partnerships with agencies in our community. One agency that we have a partnership with is Spindletop Center. Spindletop is our local mental health center in the Southeast Texas region. And we have some individuals who are here from Spindletop. They're gonna come to you in a few minutes and tell you more about the program. But basically what Spindletop does, they have the expertise to address any of your mental health needs. For example, if you suffer from, now, first of all, you do not have to be incompetent or insane. You can just merely suffer from depression or anxiety or any host of mental illnesses. Spindletop has the expertise to address those issues. Now, with Spindletop, they will, first of all, conduct a private interview, either in our jury room or at their facilities or by telephone, whichever is convenient for you. Then they can do an assessment to determine what your mental issue may be, and then they can develop a treatment plan to address your mental issue. Spindletop also has a program that is called, it's an acronym ATAR, ATAR, stands for Addiction Treatment and Recovery. It's a drug and recovery program that Spindletop has. We also have a partnership with our local Drug and Alcohol Council that has a program that is called OSAR, OSAR, stands for Outreach Screening, Assessment, and Referral. Both of those programs are drug and alcohol recovery programs, and what they will do, they will first of all do a private screening, then an assessment, and develop a treatment plan for either outpatient or inpatient treatment. If you are unemployed, or if you're looking for a better job, well, we have a partnership with the Golden Triangle Empowerment Center that has a partnership with Lamar University. Lamar University has a program that is called CICE. CICE stands for Center Innovation, Commercialization, and Entrepreneurship. It's a job training and a job placement program in the hotel industry, the shipping industry, or the chemical industry. Once you are trained in any one of those areas, they will assist you at getting a job in the area that you train in. Now, if you have not graduated from high school or you do not have a GED, CICE also has a GED program where you can receive your graduate equivalency diploma. Now, all of these programs that I just mentioned to you are free. Does not cost you anything but time. And I like to say in this book, we do not just give time, we take our time. That is, we do not just arrest the problem, we address the problem. And we believe that if we address the problem, we can produce productive people. And if we produce productive people will not commit crimes. Why? Because they got too much to lose. And so I say that when you come to county court at law number 2, we do not just have court as usual. We have unusual court. And that does not mean, that simply means that we're not saying that we're different. We're saying that we're trying to make a difference in the lives of the individuals that come before this court. And if we make a difference in their life, we'll make a difference in their home. And if we make a difference in their home, we'll make a difference in the community, because what comes out of the home goes into the community. And so, if you're interested in any one of these programs, just let us know. We have brochures, and we could direct you to the place or to individuals that can help you to get into this program. Now, the program basically is designed to get people out of the cycle of crime. And what that cycle is this: don't have an education, you can't get a job. You can't get a job, you get depressed. You get depressed, you turn to drugs and alcohol. Once you turn to drugs and alcohol, you eventually commit a crime, and once you commit a crime, you eventually get caught and do time. And once you do time, you get back out. And guess what? You're in the same old circle, right? And so this program is designed to address that issue of recidivism. So again, if you're interested, just let us know, and we'll be happy to point you in the right direction. And as I mentioned to you earlier, we have some folks from Spindletop. We have Caitlin And we have Deputy Hinton, they're gonna come to you now and tell you more about the program that Spindletop has to offer.
Thank you, John.
You're welcome.
Good morning. My name is Steve Henn. I'm a mental health deputy licensed by the state commissioner here with the sheriff's department. This is Caitlin, my coworker. Now, she is a qualified mental health professional with Spindletop. The reason we are both here in this courtroom this morning is the judge cares about every single person who comes before the bench. If the judge has found, the statistics prove, those who have legal issues commonly have mental health needs, substance use disorders, or sometimes just a lack of community resources to help you in your particular situations. And maybe this is your first time to be in court, maybe it's your fifth time to be in court. There's still hope. In fact, what we're offering you today has the ability to change your life. But we're gonna need something from you. We're gonna need you to share that need with us, and Caitlin's gonna explain exactly how you can do that very privately.
The piece of paper that I passed out to everybody, well, I hope I did, did anybody not get this? Okay, so on this piece of paper at the top is basic information, name, address, birthday, and phone number. We need those things to be able to contact you and to put you in our system. And then under it is how would you like to be contacted, and it's call, text, or email. Whatever you check is how I will contact you. I won't contact you in a way that isn't checked on the spot. And then under that is what do I need help with? And it's a whole bunch of options. Mental health is one of them. And that can be depression, anxiety, PTSD, and substance use can be any type of drug or alcohol. And if you want to talk to me today, specifically, you can write anywhere on the paper that you want me to call you today, or you want to talk today. And if you want to talk today in person, then when the judge calls you up, and then you're free to go, then I'll bring you to a private room and then we can talk about whatever it is that you need to talk about. But other than that, you can just tell me to call you today, and if you don't care if I call you today, you can just tell me to call.
Also have this, the first resource I'll actually be able to provide for you today. It's a 1-800 number. If you ever find yourself in an unsafe place, and you can call that number and you can get help immediately. And again, that's the first resource we'll be able to provide for you today. And shortly, the court's going to go into recess. And when it does, we'll be able to come out there. We'll visit with you. We'll answer any questions. We'll pick up those documents, and I'll be handing one of these to everyone who wants one at that time. Thank you. Thank you, Your Honor.
Okay, thank you, Deputy Hinton. Okay, now, ladies and gentlemen, we get ready to go into, we're gonna have a break, and really what we're gonna have a recess is to give you time to finish filling out the paperwork. Now, once that paperwork is filled out, we're going to pick that paperwork up, and then we're gonna call you up before the bench one at a time. We're gonna put you into one of three categories, either the category to hire an attorney, a category to apply for a court-appointed attorney, or the category to represent yourself. Now, those of you who will be representing yourself, you'll have an opportunity to talk to one of the two prosecutors, okay? Now, this is gonna take us a little time to pick up the paperwork if you need to use the restroom. There are two restrooms right outside in the hall. The women's restroom is in front of County Court at law number 3. No, the women's restroom is in front of the 172nd District Court, which is across the hall from County Court at law number 3. And the men's restroom is in front of County Court at law number 3. You'll be allowed to use the restrooms. Now, do not leave the courthouse. If you leave the courthouse and if your name is called and you're not here, your bond can be revoked, and if your bond is revoked, the warrant will be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail. Now, if you need assistance with filling out the paperwork, we have our court personnel who's here, including me, and we'll ask you to come up, just raise your hand, and we'll ask you to come up and we'll help you to fill out the paperwork. We'll be able to answer any questions that you have. Okay, does everyone understand? Okay, so at this time, the court is going to be in recess. Those individuals who need help to fill out the paperwork, just let us know. Just raise your hand, and then we'll come out and help you, or we'll have you come up. Okay, all right. So court is in recess at this time.
Please,
Till we get all of this here done.
don't leave out until you're done completing that. Yeah, go to the restroom, go ahead.
Call your name, please come forward. Paul Edward Alpo. Mr. Alpo, your full name is Paul Edward Alpo?
Yes.
Mr. Alpo, would you please raise your right hand? Mr. Alpo, do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Alpo, you may put your hand down. How are you doing, Mr. Alpo?
I'm good.
That's good. Now, Mr. Alpo, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Oh, yes.
Is this your signature on the line that's titled Defendant?
Yes, sir.
And are these your initials on the line that state you'd like to have your case reset to hire your own attorney?
Yes.
Now, Mr. Alpo, before you sign this document, signed and initialed this document, did you read the document? Did you understand what you read? Is everything in this document true and correct to the best of your knowledge?
Yeah.
Okay, Mr. Alpo, your case is going to be reset, give you an opportunity to hire an attorney. Please, have us stand in front of the court coordinator. She's gonna reset your case. Once you get your case reset, you're free to go and you have a blessed day. Humberto Antonio Monguia Ruiz. Mr. Ruiz, your full name is Humberto Antonio Monguia Ruiz.
Yes, sir.
Mr. Ruiz, would you please raise your right hand? You swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? You may put your hand down. Mr. Ruiz. Put your hand down. How are you doing? You're doing good. I'm doing fine. Thanks, Max. Now, I'm showing you a document. Do you recognize this document? Judge's Explanation of Rights to Defendant.
Yes,
Attorney, is this, that door is locked, sir? You gotta, the only one door is locked. You have to, is this your signature on the line that's titled Defendant?
Yes, sir.
And are these your initials on the line state you'd like to have your case reset to hire your own attorney? Now, before you sign this document, did you read the document? Did you understand what you read?
Yes, sir.
And is everything in this document true and correct to the best of your knowledge? Okay, Mr. Ruiz, your case is going to be reset to give you a chance to hire an attorney. Please stand in front of the court coordinator. Donna Monique Collier. Shawana Monique Collier. Ms. Collier, your full name is Shawana Monique Collier.
Yes,
Ms. Collier, would you please raise your right hand. Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
yes,
You may put your hand down. How are you doing, Ms. Collier?
all right.
I'm doing fine. Thanks for asking, Ms. Collier. I have for me document that is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes,
And is this your signature on the line that's titled Defendant? And are these your initials on the line that state you've hired Kevin Lane? Now, before you sign this document, did you read the document?
yes, sir.
Did you understand what you read?
Yes.
And is everything in this document true and correct to the best of your knowledge?
Yes.
Okay, Ms. Collier, you can have a seat in the second chair and wait for your name to be called by the court coordinator. Once your name is called, you go to the window, and once you finish, you're free to go on your blessed day.
Ms. Collier. William. You see like that. And she points at. Okay.
Thank you, ma'am.
Uh-huh.
Anthony Jacob Cormier. Is that the gentleman that stepped out?
No. Step down.
Okay,
I
Anthony,
have one here on.
I have Anthony Jacob Cormier on page 2. Cormier or Cormier. Well, that's all right. Yeah, we'll wait for him to come back in. Huh? He's on my list.
Well, I didn't have him check as being here.
He came in late. Yeah, that's the gentleman that came in late.
And he left that when we went to recess. He took off.
Okay, well, we'll call his name
The guy in
again.
blue,
I don't know. Watkins, let's see. Bobby Watkins? Mr. Watkins, your full name is Bobby Glenn Watkins? Mr. Watkins, would you please raise your right hand? Mr. Watkins, do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Watkins, you may put your hand up. How you doing, Mr. Watkins?
Yes, sir.
You doing good? That's good. Now, Mr. Watkins, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes,
And is this your signature on the line that's titled Defendant?
yes, sir.
And all these initials on the line state you want your case reset to hire your own attorney?
Yes, sir.
Mr. Watkins, before you sign and initial this document, did you read the document?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in this document true and correct to the best of your knowledge?
Yes, sir.
Okay, Mr. Watkins, I read your answers. Your case is going to be reset to give you an opportunity to hire an attorney. Our work coordinator is going to give you a reset. Once you get your reset, you're free to go. You have a blessed day. Please have a seat in that first chair.
Okay.
You're welcome. Jose Tiarena Saavedra. Mr. Tiarena Saavedra, would you please raise your right hand? Swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? You may put your hand down. Your full name is Jose.
Eleno, Gerina, Jose Eleno, Gerina Saavedra.
Okay. And how are you doing?
All right.
That's good. Now, Mr. Saavedra, I have before me 2 documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes,
Is this your signature on the line that's titled Defendant?
yes,
And are these your initials on the line that state you like to apply for a court-appointed attorney? I also have another document that is titled Jefferson County Affidavit of Indigence. You recognize this document?
yes,
On page 2, there's a signature above the line that's titled Defendant Signature. Is this your signature?
yes,
Now, Mr. Saavedra, before you signed and initialed these documents, did you read the document?
yes,
You understand what you read?
yes,
Everything in these documents true and correct to the best of your knowledge?
yes,
Okay, Mr. Saavedra, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of court-appointed attorney. And the attorney that will be appointed to represent you is Attorney Joel Vasquez. Attorney Vasquez will give information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you're free to go, and you have a blessed day. Please have a seat in that first chair on the wall. James Harrison. Now, Mr. Harrison, your full name is James Cody Harrison? Mr. Harrison, would you please raise your right hand? Mr. Harrison, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Harrison, you may put your hand down. How are you doing, Mr. Harrison? I'm doing fine, thanks for asking. Mr. Harrison, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Well, first document is titled Judge's Explanation of Defendants Without Attorney. You recognize this document? And is this your signature on the line that's titled Defendant? And are these your initials stating that you like to apply for court appointed attorney? Also, I have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document? And on page 2 of the same document, there's a signature above the line that's titled, and the signature is this your signature. Mr. Harrison, before you sign and initial these documents that I just showed you, did you read the documents?
Yes.
Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Okay. Mr. Harrison, I read your answers. Based on the answers, meet the eligibility requirements for the appointment of a court appointed attorney. An attorney that will be appointed to represent you in this case is Attorney Marcus Wilkerson. Attorney Wilkerson will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. But before she gives you that information, I need to give you some bond conditions. Bailiff's gonna hand you a document that's titled Standard Bond Conditions in County Court at Law Number 2. Do you see that title? Standard Bond Conditions in County Court at Law Number 2. Okay, I'm gonna go over these bond conditions with you, and it states as follows. Following return of criminal information in County Court at Law Number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named here are ordered subject to the additional conditions. Number 1, defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition? Number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so, or B, submit to a test for drugs and alcohol, and a test indicates the presence of drugs or alcohol in the defendant's body. Do you understand that condition? And condition number 3, the defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim. Do you understand that condition? Yes. Condition number 4 does not apply. However, condition number 5 does apply. And condition number 5 states the defendant is prohibited from possessing a firearm or ammunition unless the defendant is a peace officer as defined by section 1.07 Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Mr. Harrison, do you understand that condition? Now, Mr. Harrison, if you violate any one of these conditions, your bond will be revoked, and once your bond is revoked, you'll be arrested and placed in the Jefferson County Jail. Please have a seat in the first channel wall and wait for your name to be called. Juana Nicole Torres. Ms. Toran, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Okay, you may put your hand, Ms. Toran. Your full name is Tawana Nicole Toran. Okay, how are you doing, Ms. Toran? I'm doing fine, thanks for asking, Ms. Toran. I have before me two documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? Is this your signature on the line that's titled Defendant? Yes. And are these your initials on the line that states you'd like to apply for court appointed attorney? I also have another document that is titled Jefferson County Affidavit of Indigence. You recognize this document? Yes, sir. On page 2 of this same document, there's a signature above the line that is titled Defendant Signature. Is this your signature? Yes. Now, Ms. Toran, before you sign and initial these documents, did you read the documents? Did you understand what you read? Is everything in these documents true and correct to the best of your knowledge?
Yes.
Okay, Ms. Torrad, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you is Attorney Nathan Reynolds. Attorney Reynolds will be given information to contact you. And you will also be given information to contact him. Our court coordinator is going to give you that information. Once she gives you that information, you'll be free to go and you have a blessed day. Please have a seat in the second chair on the wall. Melvin Palmer. Mr. Palmer, would you please raise your right hand? You swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Okay, you may put your hand down. How are you doing, Mr. Palmer? Okay, now, Mr. Palmer, your full name is Melvin Ray Palmer Jr.? Okay. Now, Mr. Palmer, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? You have to speak up.
Yes, sir.
Is this your signature on the line that's titled Defendant?
Yes, sir.
And are these your initials on the line that state you'd like to apply for court-appointed attorney? I also have another document that is titled Jefferson County Affidavit of Indigence. You recognize this document? On page 2 of the same document, the signature above the line is titled Defendant Signature. Is this your signature? Now, Mr. Palmer, before you sign and initial these documents, did your attorney, did you read the documents? And did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Mr. Palmer, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Marva Provo. Attorney Provo will give information to contact you, and you will be given information to contact her. Our court coordinator is going to give you that information. Once she gives you that information, you'll be free to go on your blessed day. Please have a seat in that third chair on the wall. Ariana Lachey Darcy. Okay, Ms. Darcy, your full name is Ariana Lachey Darcy. Ms. Darcy, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? You may put your hand down, Ms. Darcy. Ms. Darcy, how are you doing?
Good.
I'm doing fine, thanks for asking. Ms. Darcy, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? And is this your signature on the line that's titled Defendant? And are these your initials on the line that state you like to apply for court-appointed attorney? I also have another document that is titled Jefferson County Affidavit of Indigence. You recognize this document? And on page 2 of this document, there's a signature above the line that is titled Defendant Signature. You recognize this? Is this your signature? Now, Ms. Darcy, before you sign and initial these documents, did you read the documents? Do you understand what you read? And is everything in these documents true and correct to the best of your knowledge?
Yes.
Good. And Ms. Darcy, I read your answers. Based on your answers, you do not meet the eligibility requirements for the appointment of a court-appointed attorney. Okay? So at this point, you have two other options. You could either have your case reset to hire your own attorney, or you can waive your right to an attorney and represent yourself. Okay, now do you know what you want to do?
I'll give it.
Okay, could she's gonna give you this here. You're gonna make your change on it. Just strike a line through. Okay, so your case is gonna be reset to give you an opportunity to hire an attorney. Once your case is reset by our court coordinator, you're free to go. And you have a blessed day. Please have a seat in that first chair on the wall. Christopher Bosaro. Mr. Bosaro, your full name is Christopher Bosaro?
Yeah.
Mr. Bosaro, would you please raise your right hand? Swear affirm and tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
Mr. Basaro, you may put your hand down. How you doing, Mr. Basaro?
Okay.
That's good. Mr. Basaro, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir.
Is this your signature on the line that's titled Defendant?
Yes, sir.
And are these your initials on the line that state you'd like to apply for a court-appointed attorney?
Yes,
And I also have another document that's titled Jefferson County Affidavit of Indigence. You recognize this document?
yes, sir.
On page 2 of the same document, there's a signature above the line that is titled Defendant Signature. Is this your signature?
Yes, sir.
Now, Mr. Basara, before you sign and initial these documents, did you read the documents?
Yeah.
You understand what you read?
Yeah.
Is everything in these documents true and correct to the best of your knowledge? Okay, Mr. Basara, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney, and the attorney that will be appointed to represent you in this case is Attorney Laurie Perazo. Attorney Perazo will be given information to contact you, and you will be given information to contact her. Our court coordinator will give you that information. Once you get that information, you're free to go and you have a blessed day. Please have a seat on that 4th chair on the wall. Damian Nixon. Mr. Nixon, would you please raise your right hand? Mr. Nixon, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Nixon, you may put your hand down. How are you doing, Mr. Nixon? I'm doing fine, thanks for asking. Now, Mr. Nixon, your full name is Damian Nixon Senior? Okay. Mr. Nixon, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
And are these your initials on the line that state you'd like to apply for a court-appointed attorney?
Yes, sir.
I also have a document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes, sir.
And on page 2 of the same document, there's a signature above the line that is titled Defendant Signature. Is this your signature?
Yes, sir.
Now, Mr. Nixon, before you sign this and initial these documents that I just showed you, did you read the documents? Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Okay, Mr. Nixon, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney, and the attorney that will be appointed to represent you in this case is Attorney Langston Adams. Mr. Adams will be given information to contact you. You will be given information to contact him. Our court coordinator will give you that information. Once you get that information, you'll be free to go, and you have a blessed day.
You too.
Full speed. This is cause number 24 CCCR 2980, case of style of state of Texas versus Kenesha Williams.
Yes.
Ms. Williams, is that your full name?
Nisha Monique.
Kenesha Monique Williams? Okay. Ms. Williams, would you please raise your right hand? You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Ms. Williams, you may put your hand down. How are you doing, Ms. Williams? That's good. Now, Ms. Williams, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document? Is this your signature on the line that's titled defendant?
Yes.
Are these your initials on the line that state you've hired, it must be Dustin Galmore?
A.
There's no A Galmore, it's a D Galmore.
Oh, well, yeah.
Yeah, okay. Who did you hire?
It's Galmore. I don't know his first initial. I had his phone number though to confirm.
Okay, well, it's Dustin Galmore. All right. So, now, before, you can make the correction, she can make the correction that it's a A, she should be D. Dustin. His office is right across the street. His office is about a block from the courthouse. Have you been to his office?
No, we just talked over the phone.
Oh. Okay, so you've hired him or you going to hire him?
Yes, I just haven't,
So you have not hired him.
well, I have hired him,
Do you pay him?
just not the whole thing yet.
Okay, you paid
Because
him
I've been working
a
with him, so that's what
retainer?
they told me to tell you when I got here.
Okay, well, he hadn't submitted, has he submitted a,
I don't know.
hold on, let me look at your file. Yeah, I don't see a letter of representation in your file, so apparently you must have paid him something, but I don't think, because the reason why I'm saying that, if you would have fully hired him, he would have sent a letter to the court indicating to the court
Mhm.
that he is representing you. He has not sent a
Okay.
letter to the court. Okay? So now, before you sign this document, did you read the document?
Yes.
You understand what you read?
Mhm.
And is everything in this document true and correct to the best of your knowledge?
Yes.
Okay. Now, Ms. Williams, your case is going to be reset to give you an opportunity to hire Mr. Galmore.
Okay.
Our work coordinator is going to give you the reset date. Before she gives you that reset date, I need to give you some bond conditions. You have a document before you that is titled Standard Bond Conditions in County Court at Law Number 2, is that correct?
Mhm.
I'm going to go over this document with you, and it states that following the return of a criminal information in County Court at Law Number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, defendant shall commit no offense against the laws of this state, any other state, or against the United States. Do you understand that condition?
Yes.
Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. Court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs and alcohol in the defendant's body. You understand that condition?
Yes.
And condition number 2, the defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense, and the defendant shall not go near any residence or other location frequented by the alleged victim. Do you understand that? Now, that also, when I says do not communicate either directly or indirectly, that also includes Facebook, Instagram, or any type of social media posts. Do you understand that? Now, on condition number 4 does not apply. Condition number 5 does apply. And it states the defendant is prohibited from possessing a firearm ammunition unless the defendant is a peace officer as defined by section 1.07 of the Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Do you understand that condition?
Yes, sir.
Now, if you violate any of these conditions, your bond can be revoked, and if your bond is revoked, A warrant will be issued for your arrest. You will be arrested and placed in the Jefferson County Jail. Do you understand? Okay, have a seat in that first chair on the wall. Oh, stand in front of the court coordinator, wait for your name to call. Once you finish there, you're free to go in your destination. Garrett Simmons. Okay, Mr. Simmons, your full name is Garrett Simmons.
Here.
Okay, how are you doing, Mr. Simmons?
I'm doing good. How about yourself?
I'm doing fine. Thanks for asking. Mr. Simmons, would you please raise your right hand? Simmons, do you swear affirm to tell the truth, the whole truth, and nothing but the truth so help you God?
Yes.
Mr. Simmons, you may put your hand down. Mr. Simmons, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
And are these your initials on the line that state
Yes.
you like to apply for a court-appointed attorney? Now, Mr. Simmons, I also have a document before me that is titled Jefferson County Affidavit of Innocence. You recognize this document?
Yes, sir.
On page 2 of the same document, there's a signature above the line that is titled Defendant Signature. Is this your signature?
Yes, sir.
Now, Mr. Simmons, before you sign and initial these documents that I just showed you, did you read the document?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct
Yes, sir.
to the best of your knowledge?
Yes, sir.
Now, Mr. Simmons, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Don Boudreaux. Attorney Boudreaux will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information, but before she gives you that information, I need to give you some bond conditions. The bailiff is gonna hand you a document that's titled Standard Bond Conditions in County Court Law Number 2. You see that document, that title?
Yes, sir.
I'm gonna go over this document with you. Where's the second page of this document? Okay, and this document states standard bond conditions in County Court at Law Number 2. Following return of a criminal information in County Court at Law Number 2, of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition?
Yes, sir.
Condition number 2, the defendant shall submit to testing for drugs and alcohol as any time as directed by the court, and the court may revoke the bond of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition?
Yes, sir.
And condition number 3, the defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim. Do you understand that condition?
Yes.
Condition number 4 does not apply. Condition number 5 does apply. And the state's defendant is prohibited from possessing a firearm or ammunition unless defendant is a peace officer as defined by section 1.07 of the penal code, actively engaged in employment as a sworn, full-time, paid employee of a state agency or political subdivision. Now, Mr. Simmons, do you understand
Yes.
that condition?
Yes, sir.
Now, that's the last condition on your bond, is that correct?
Yes, sir. I don't know. What happened or anything.
Okay, but that's the last condition, right?
Yes, sir.
Now, if you violate any one of these conditions, if your bond can be revoked, and if your bond is revoked, a warrant will be issued for your arrest, you'll be arrested and placed in the Jefferson County Jail. Mr. Simmons, please stand in front of the court coordinator. Wait for your name to be called. Once your name is called, you're free to go. And you have a blessed day. All right?
I have a question I want to ask you. Thank you for talking about last time. Where two-time offender of the same crime or something. If you commit the same crime or something.
I didn't say anything about committing the same
Earlier.
thing. Earlier, I said there's a program for first-time offenders.
No.
The one after that was, no, you're possibly talking about the CSI program.
Yeah.
Where we have the mental health treatment, job training, job placement,
Yes.
and the, drug and alcohol
Yes.
treatment. So you need
Family time, right?
spindle top. You need information.
That paper.
Yes.
This is what,
That's spindle top?
yeah.
Okay,
Thank you.
okay.
But it should be contacted.
What's your name? It should be contacted within 24 hours of the number you gave. If you have any questions before we close it, this information. Thank you.
Okay. Natasha Broussard, you please come forward. Ms. Broussard, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize, well, first of all, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
You may put your hand down. Now, Ms. Broussard, your full name is Natasha
Italia Broussard.
Italia Broussard. How are you doing?
I'm well and yourself.
I'm doing fine, thanks for asking. Now, Ms. Broussard, this document that is titled Judge's Explanation of Rights to Defendants Without Attorney, you recognize this document? And is this your signature on the line that's titled defendant?
Yes.
And are these your initials on the line that state you'd like to waive your right to an attorney and represent yourself?
Yes.
Also have another document that is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. Do you recognize this document?
Yes.
And is this your signature on the line that's titled defendant? Now, Ms. Broussard, before you sign and initial these documents, did you read the documents? Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Now, Ms. Broussard, you talked to the prosecutor about your case, is that correct?
Yes.
And you have not been able to reach an agreement, is that correct?
No, he said that we would be able to talk in his office about the evidence tonight.
Okay, yes. So that what that basically means is that you have not working on an agreement and you still want to go forward on your case by representing yourself.
Yes.
Okay. Now, Ms. Broussard, I need to go over something that's called a Faretta warning. And, I have pursuant to the Ferretta versus California, 422 US, which is Supreme Court 806. I need to ask you some questions. The first question, have you ever studied law?
No.
Have you ever represented yourself in a criminal action?
No.
Do you understand the charges against you?
Yes,
You do. And do you know,
he said that it was, license suspension of motor vehicle.
well, so it's a Class C misdemeanor.
Yes, I presume.
Okay, let's do this here. The case was appealed. Now, this case was appealed from municipal court.
Yes.
So it's the same charge that you had in municipal court,
Yes.
okay? Says Bruce. Okay, you was charged with the offense of driving while license invalid. Okay, now, and do you understand the range of punishment for that offense?
I do not.
You could be given a fine up to $500. The next question is, you realize that if you represent yourself, you are on your own? As a judge, I cannot tell you how you should try your case or even advise you as to how you should try your case. I cannot help you in any way. Do you understand that? Are you familiar with the Texas rules of evidence and Texas case law?
No.
Do you realize that the Texas rules of evidence and Texas case law govern what evidence is admitted, and in representing yourself, you must abide by those rules? Okay, for example, how do you conduct, do you know how to conduct a voir dire? That's speaking a jury. And do you know what are the grounds for excusing a juror for cause?
No.
Do you know what is hearsay?
No.
Do you, and what are some of the exceptions to hearsay? No. Do you know what is proper impeachment of a witness?
No.
And do you know when is character evidence allowed in a case or in a trial? Do you know when and how to make proper objections? Do you know when and how to move for a directed verdict?
No.
Do you know how to proffer or offer evidence to protect the record for appeal?
No.
Do you know the proper grounds for mistrial?
No.
Are you aware that failure to timely move for mistrial may waive crucial mistakes made by the state or this court? Okay. Do you know how to request and object to jury instructions? Are you familiar with the Texas rules of criminal procedure?
Yes.
Do you realize that those rules govern the way in which a criminal action is tried in court? Okay. Now, I must advise you that, in my opinion, you would be far better defended by a trained lawyer than you can be by yourself. I think it is unwise for you to represent yourself. You are not familiar with the law. You're not familiar with the court procedure. You're not familiar with the rules of evidence. I would strongly urge you not to try and represent yourself. Now, in light of the penalty that you might suffer if you are found guilty, and in light of all the difficulties of representing yourself, is it still your desire to represent yourself and to give up your right to being represented by an attorney? You do? Okay,
I still wanna represent myself. That's what I'm saying.
okay, so is it your decision, is your decision entirely voluntarily on your part?
Yes.
Okay? Okay, I would find that the defendant has knowingly and voluntarily waived her right to counsel. I will therefore permit her to represent herself. So okay, Ms. Broussard, your case is gonna be reset. You'll have an opportunity to visit with the criminal district attorney. I'm sure he's gonna you're gonna set an appointment to visit him, and he'll allow you to have, access to the discovery. Okay? Please stand, you ready for it? Please stand by the window and wait for your next, and, once you finish at the window, you're free to go. You have a blessed day. No, announcement. Okay. Anthony. Anthony Jacob Cormier, cause number 24 CCCR 2842. Mr. Cormier. His name was called at 9 a.m. Because the court was set at 9 a.m. on today's date of February 4th, 2025. At that time, he did not answer. He did appear in court late. And after or during the arraignment, he left. He's not here at this time. The time now is 12:47 a.m. on today's date. Excuse me, 11:47 on today's date. Ms. Bailiff, would you please call the name of Anthony Cormier or Cormier at the courthouse door?
Yes, yes, sir. Anthony Cormier. Anthony Cormier. No response, Your Honor.
Okay, Anthony Cormier's name was just called at the courthouse door. Anthony Cormier did not answer. A reasonable time has passed to give Mr. Cormier an opportunity to appear in court. State, do you have a motion?
St. Louis for bond forfeiture.
That motion will be granted. Anthony Cormier's bond will be forfeited, and a warrant shall be issued for his arrest in cause number 24 CCCR 2842. Jameson Barker. Jameson Barker was scheduled to be in court this morning at 9 a.m. at or about 9 a.m. Jameson Barker's name was called. Jameson Barker did not answer. Jameson Barker has not appeared in court since the court has been in session. The time now is 11:48 a.m. on today's date. Ms. Bailiff, would you please call the name of Jameson Barker at the courthouse door?
James Parker. James Parker. No response, Your Honor.
Jameson Barker's name was just called at the courthouse door. Jameson Barker did not answer. A reasonable time has passed to give Mr. Barker an opportunity to appear in court. State, do you have a motion?
Your Honor, still ask for a bond forfeiture.
That motion will be granted. Jameson Barker's bond will be forfeited and a warrant shall be issued for his arrest.
Joshua Kennedy's in the hospital. That's, I got
Well,
no
it needs
information
to
from
go
him.
to mom. We have more than that, I think, so.
Okay.
In the morning, looks like. Here it comes.
Next case is cause number, well, the next two cases are cause numbers 23 CCCR 1990.
He's in jail.
Oh, he's in jail? Okay. Well,
The same building.
Okay. well, the next one. That's it.
Who's that in jail?
This will conclude, this will conclude the calling of the court's arraignment docket on today's date, February 4th, 2025. In County Court at Law Number 2, Jefferson County, Texas. Judge Terrence L. Holmes presiding. Court will be in recess until 1:30. And at that time, we will continue with our trial. 1:30 this afternoon. Prosecutors, you're excused.